All right, let's get going. So, like I said, thank you everyone for being here. You're in the right place. This is the Legal Rights of Union Stewards and Committee Persons, a webinar by UAWD, Unite All Workers for Democracy, the Reform Caucus in the UAW. UAWD stands for a member-run union, a militant union, and a more democratic union. We fought and won against corruption. We fought and won one member, one vote. We elected new reform leadership, UAW Members United slate, including Sean Fain, to the leadership of the UAW. And now we are making sure that all members of the union, whether you're a local officer, whether you're a rank and file member, have educational resources that you need to build a stronger UAW. So thank you so much for being here, everyone. I'm going to introduce our um, our presenters. All right, we have Will Bloom, a labor lawyer at Dupre, Schwartz, and Gagan, who is actually a former UAW member of Local 2320. And we have Ricky Brand, the current vice president of UAW Local 897, that's the Buffalo stamping plant, and a former shop committee member at Local 897. So thank you so much for our presenters being here today. I'm just going to quickly run through the workshop agenda, and then I'm going to hand it over to them. So first, we're going to go over the basic rights and responsibilities of union stewards and committee people. We're going to go over the grievance process, the union's right to information, the union's rights in meetings with management, and the duty of fair representation. And then finally, last but not least, we're going to talk about how to get members involved in the grievance procedure. It's not just about the law, but we need real power on the shop floor to back our shop stewards and committee people up. So I'm going to hand this over to Ricky now.
Hello, everybody. My name is Ricky Brand. I'm out of Local 897. I am a vice president currently. I have been a steward or a district committee person and currently active and very involved. So we're going to go over who this workshop is for. It's for everybody, right? We all need to know what our processes are, our contracts, all of that. It is for every member, whether you're a shop steward, a member on the floor, or someone thinking about getting involved. This is for you. And we're trying to make it as informational as possible so that you guys all have the tools you need going forward. Going into the next slide, we're going to use some different terminology here. In the UAW stewards, they go by a bunch of different names: shop steward, chief steward, committee person, shop committee member. During this, we're going to try and stick to just using stewards so that it's universal, but there are different legal rights based off of your shop. So now going forward, I'm going to explain a little bit of what a committee person does. If you look here on the screen, you'll see a list of these things, and all of them are very accurate. You lead in your workplace. You are the first line of defense for your membership. You're the first person that gets called. You get thrown into a lot of things. You're an agent of your union, the local and the international. You're a communicator. You are the eyes and ears for your membership and for your actual committee. You're a representative of your people. And that's the biggest thing, right? We get elected, so we are their representatives. We are there to do and serve them. You may be an organizer. I know personally we organize actions on the floor. You may even go farther into organizing other facilities. That is all part of being involved in the union and doing your due diligence. You're a negotiator. On my day-to-day as a shop committee person, or steward, I should say, we negotiate quite a bit. You're always upholding that contract and always trying to get things done. You may be negotiating in a hearing, in grievance hearings, anything like that. You're going to be on the floor negotiating daily. Usually, you're an educator, and I think this is probably one of the most important things that we got to do is make sure that we're educating our membership. Not only explain what it is, maybe get them interested in looking at it themselves, present them with the language, show them why that is important, and then move forward from there. Political activist, going back in the UAW to the days of Walter Reuther, and we should be very heavily politically active, right? We should be knowing the issues surrounding not just our facilities, but also the issues surrounding our communities and anything that has to do with it. The UAW back in the day took the stance that it wasn't just about protecting their membership in the building and their jobs. It was about everything, civil rights, anything that had to do with it. Walter Reuther was one of the first people to really be heavily involved in green ideas, right? So these are definitely huge parts of it. And then you're a problem solver. Every single day, you're going to find a new problem, something you haven't encountered. So that is definitely something that you're going to see throughout your time as a committee person. And I'm going to pass it over to Will here.
Thanks, Ricky. So yeah, this first section is on the kind of basic rights and responsibilities that come with being a union steward. I think an important note I'll just say right at the top is that there's not a clean delineation between your rights and your responsibilities. You have those rights because you have a responsibility as a steward to use them to represent your members, to represent the people that you're there to help protect. This first slide is kind of, we're going to get into some more specifics, but I think these are three really important kind of baseline, really responsibilities that you have as a steward. And that's to know your rights as a steward, but also know the rights that you and all of your coworkers have as workers, as members of the union, as under the contract. And that goes into number two, know your contract. There's a lot of the formal kind of duties that we're going to talk about. But as Ricky was saying, you're a leader on your shop floor. And so even if you're not having to enforce the contract in a given moment against the boss, I'm sure those of you who are stewards get asked a lot of questions about what's in the contract, how that contract has been applied in the past, what the history of that is. So you really have to know your contract forward and backward, basically at all times, because people are going to have questions and one of your duties is to be able to answer them. The third one here is stay connected to the issues of your union, which is really know the shop, know the members, know what's happening, because the contract is just paper unless you know how it's actually working in practice, how it's being applied, how it's being not followed. So you really need to stay in touch, talk to people, get a sense of what's going on, so that you know when there might be an issue that you need to proactively handle. So going to the next slide, we'll see some of the more concrete basic rights that a steward has, which is, as Ricky was saying, represent and lead the members. In most UAW shops I know of, stewards are elected. You're elected for a reason. You're elected to represent folks and to lead folks. And that means, and we'll talk about this later, being proactive when you think there might be an issue, asking around to see if, anything is coming up, getting a sense of what people are frustrated about so that rather than waiting for a problem to arise, you can kind of tackle it head on. Number two here, participate in investigatory interviews. We're going to talk a little about that in the next couple of slides. But when your members are being faced with discipline or when the boss is trying to get information out of them, you have both the right and the duty to be there and support them in that, to push back where appropriate, and make sure that the members are represented. The third bullet point here, right to information. We're also going to talk extensively about that. But part of the bargaining relationship is that you have a right to know what's going on in the shop insofar as it applies to your members and to the contract. And so we're going to talk a lot about information requests later on here. You also have a right to be free from retaliation. As a steward, you are a representative of the union. You're doing union business. If your boss threatens you or actually does take some action against you based on what you're doing as a steward, it's against the law. You have both the right and the duty to zealously represent the members, zealously defend and enforce the contract, and they can't mess with you when you're doing that. The final thing here is you have the right to be treated as an equal when acting as a steward. This is I think really important and something that doesn't get talked about that much, but the courts have found what's called the equality principle when stewards are acting in their duties as a steward. Basically, on the shop floor when you're doing your job, within the limits of the contract, the boss gets to, the boss is the boss. You're the worker. You have to, as far as the contract allows, do your job, follow directives. But when you are acting as a steward, you are supposed to be on an equal footing with the boss. You're on an equal footing with the employer. The system doesn't work without that. So you have a right to be treated as an equal when you're acting as a steward. That's an important thing to keep in mind. So if we go to the next slide, we're going to dig in a little bit on what it looks like when you're representing your members, when you're acting as a steward. The first thing is the right to represent a member who requests it. This is known as the Weingarten right. This Weingarten comes from a Supreme Court case which found that a member has a right in an investigatory or disciplinary or any meeting basically where there's the possibility that it could lead to discipline. A union member has a right, and arguably not yet union members as well, but we're going to leave that aside for now. But a union member has a right to be represented by a representative of their union, and in most cases, that's going to be you as the steward. That means, and we can talk a little about the specifics of that. But that means you have a right to ask questions insofar as it's relevant to the disciplinary matter in front of you. You have a right to caucus with your member, to pull them aside and have a private conversation about what might have happened and kind of get on the same page. You have a right to know the specifics of the charge that's being investigated. They can't just call someone in there and question about everything and anything under the sun. They have to actually tell you what's being investigated. And to a certain extent, you have a right to push back. You have a right to reframe things when they're kind of going in a certain direction. You have a right to present the worker's narrative of what's happening in a given situation. So can we go to the next slide? We're going to have a number of true or false polls, yes or no questions here. So Nathan, if you can get that poll going. Do members have a right to have to invoke their Weingarten rights in order to receive representation? True or false? Or it depends. All right, numbers climbing. All right. All right, that's 30 seconds. Let's call it there. So yeah, basically the right answer most of you got is true. It's a little bit, it depends, but basically the answer is yes. You do have to invoke your Weingarten rights. A member is not entitled to a representative, or they're entitled to a representative if they ask for one. But it's not like Miranda rights, for those that are familiar with that, in a criminal system where you have to be told of your right to a lawyer in order for anything they do after that to be valid. They don't have to tell members anything. But if a member invokes their Weingarten rights, they're entitled to them. Now, it depends answer. Some contracts do require that members be informed of their Weingarten rights, but unless that's in your contract, and again, you've got to know your contract backward and forward, there's no way to know for sure. That's only if that's in your contract that it's not necessary for a member to know their rights and invoke them. So be sure to educate members on that. So we've been talking a lot about kind of the rights, the abilities of being a steward. We also want to talk about some of the responsibilities that you have. It's important to remember that when you are acting as an agent of the union, you have all these rights, that equality principle, that right not to be disciplined for those actions. But those rights, with great power comes great responsibility. You have a lot of responsibilities, both to the members you're representing and to the union as an institution. When you are serving in this role, and we're going to talk about we've talked somewhat about kind of the more the less legal but more politically principled rights about being a good steward, being a good leader, all that. But there's one really important legal responsibility that you have that we'll talk about in the next slide. We're going to talk about this in more detail later. But you have a duty of fair representation. You might hear the term DFR, a DFR claim. That's the duty of fair representation. This is basically that you have a duty to the members of the bargaining unit, whether or not they're actually paying their dues, whether or not they're in the union, even if they're just paying, their free rider fees, you still have a duty to represent them. You can't avoid, you have to, treat unit employees, union members or not, other delineations or not, in a fair manner, in a not arbitrary manner, not discriminatory manner. You have to treat similar cases similarly, equal cases equally. You need to make an investigation and show your work about why you're making the decision you're making. This is without getting too deep into it, this is an interesting body of law where on the one hand, like a lot of people who bring DFR cases are not always acting in the best faith and maybe are not always the easiest people to work with. But not only do we, owe everybody in the shop, our best ability and our best that we can. It's more to remember that this kind of area of law kind of came about, in the 40s when Black workers weren't allowed to join unions and some discriminatory officers were not treating them in the non-discriminatory manner they needed to be treated. So the duty of fair representation, as frustrating as it can be sometimes on the ground, serves a really important purpose, one that's important to keep in mind. That when you're acting as this leader in the shop, you owe a duty to lead everybody in the shop, even those that don't necessarily agree with you in a given moment. And we'll talk about that more later, but the last responsibility of the steward, and we put this at the beginning, we put this at the end of the section. You need to know your contract. You can't enforce a document that you don't know. But it's important, these contracts are complicated, especially big three contracts have, riders and attachments and so many different, the contract can be 5 or 6 different documents. So don't be afraid to ask for help from other more experienced stewards, from staff, from your union's officers, from, just anybody you can. And don't be afraid to research, most of these contracts and various, all these documents are findable. And you can look them up, you can cross-check them against things. So don't be afraid to do that research and make sure that you are actually knowing what you're enforcing. When it comes to enforcing the contract, we do that through grievances. I'm going to pass it back to Ricky to talk about what that looks like.
So grievances, for those who don't know, is what is listed here on the slide. It's a violation of the contract. It's a violation of the company's policies and or procedures. Unfair treatment to an individual or group. It's a violation of a past practice. It's a violation of a law. All of these things are grievances, and not just limited to. You, as a grievance writer, will learn that you have to be able to look at every issue as an individual issue, investigate it, and go forward. And we will start getting into that here. So moving on to the next slide. This is not for Will. No one tell Will about this one, all right? Keep your ears closed. So arbitrations, they're won by what you put into this grievance, by the investigation that you do. So before I ever write a grievance, the first things I had done would go into depth of every detail of it, make sure that the information that was provided to me is accurate so that I knew going into it was right, and then find as much information as possible to make it heavy and legitimate. So when it does make its way down the line, they're using the information you provide to win the arbitration. So that's starting at drafting the grievance, the investigation, and getting all the documents possible. These are huge, and this is where your job is extremely important, because doing this properly and good at the start sets it up for everyone down the line, no matter how far this grievance goes. So investigating the grievance. There are, if anyone has done this before, if you're not, there are the 5 W's. Who, what, when, where, and why. Those are how you're going to investigate every single grievance. Who is it about? Who's involved? Who? All the ways you can ask who, that's what you're looking up. What is it? What's the violation? What happened? What led to it happening? And I find that if you think that question right there, what led to this happening, that's the best way to start finding the starting point of where this violation occurred or maybe continuously occurs. When did it happen? That's your timeline, dates, where, the locations, and then why. Why was this violation allowed to happen? Why did it occur? All of that. And then most importantly, when you write a grievance, you're going to need to ask for a remedy. So in the investigation, you got to figure out what was lost because of this violation. You got to figure out what is needed to make it whole. So moving on to the next slide here, investigating the grievance. Like Will had said, you have a right to a lot of information, and you need to utilize that right as you're going into your investigation. As long as it is pertinent to your grievance, you have the right to look it up and ask for it. I usually do this a lot of times through email because it's written and it's tracked. So you're looking for work record and history, the seniority date, discipline or disciplinary records, and anything else that you could figure that would help you build a case against this. As we are not lawyers, we maybe don't know everything, but you need to put your lawyer head on when you're starting to do an investigation here and look for anything that's going to help you solidify this case. Then to conclude it, you're going to recap, discuss why it may be a grievance, relevant to the contract, anything. If there's legitimacy to it, that is your job to figure out at the start before you even write it. Explain what happens next to the membership. You want to make sure throughout the grievance process, you are explaining to the member who is on the grievance that where you're at, where it's going, and even afterwards, we'll get into it, but what happened with it? And then never, ever promise a victory. I can't tell you how important that is. You need to always say, we are looking into it. We're going to fight it to our best of our ability, but you can't promise the outcome of a grievance. There are many different ways that could come back to bite you in the long run. And I've seen it happen to many people as I've learned and grown and written more than enough grievances. So moving on to the next slide, we are going to look into the timeliness. So in my facility, we have a 3-day time period on both ends of it. We give them 3 days once it's served. They have 3 days to get it back. It could be different in anyone's contracts. By the way, a CBA is a collective bargaining agreement or a contract. There's multiple different ways people talk about their contracts. We'll just call them all contracts here to keep it kind of universal. But your timelines are important because you're trying to make sure that the process is moving forward. And if you don't follow timelines, there's processes that can unfold from there. It's just not good. But use brief and accurate information. So I'm going to give a brief example of a overtime grievance that we would write. You would start out with the aggrieved was bypassed for overtime on this date. The company used the protested in this place. The union and the aggrieved demand that this action will stop at once for the aggrieved to be paid so much, whatever it will be, and for any other remedies to be made whole. It's not a big paragraph. It's not a bunch of stuff, but it's telling you what happened, to who, why, what we're demanding, and then what our remedy is. And we always put that at the end for any other remedies to be made whole, because it leaves it open for the person bargaining it down the road to be able to get as much as possible out of that grievance. You want to stay away from inflammatory language. That should definitely not be in there. It's one thing to be able to have the discussion on the floor, but yeah, do not be writing those on legal documents for sure. And then ask for help. When I started as an alternate, and I kind of just got tossed into it, and I didn't always know what I was doing. So you are usually surrounded by people who have some knowledge, whether it's your elected people or people who have done it in the past that you may know. Ask them for help. Ask them for differences in how to write the language, where the violations are. Sometimes grievance can be more than one violation. It's not just one thing. So asking for help is definitely a big part of making sure you're doing your membership justice in writing this grievance. Moving on, these are the 3 parts of the grievance, like I kind of went through on the basic overtime one. The nature of the grievance. What is the violation? What happened? What are the facts of it? The violations itself, what part of the contract is it violating? I usually put that language right as a header in the body of the grievance. And then the remedy or settlement sought. And one of the things I always say is don't ask for the remedy, demand it. We're demanding that this is done. We're not asking you to do this. We have an agreement with this company, so we are going to make sure that agreement is upheld. That is our job as the stewards. So we're going to do everything we can to make sure that that's done. And you have the right to use that language. And actually, it's, as I've been taught, it's supposed to be in there. You're not supposed to ask, you're supposed to demand. So we're going to move on to a poll here. So this is one that's usually back and forth. I've heard it a bunch of different ways, but take a minute and decide, as a shop steward, are you not allowed to solicit grievances? So we're definitely getting people voting here. Let's see. All right. So right now most people are saying false. The answer is you are allowed to solicit a grievance. It just depends on if there's specific language in your contract that states that you can't. But besides that, that is your job. You are supposed to go out and enforce the contract. And if there are violations of that contract, you should be going and making sure that they're grieved and done in the proper way. Now, your right to information from management. So we're going to do another poll. Management has to turn over information to the union. Let's see what you guys think. It's a lot different than the last one. Okay, so right now we're at a majority of true. the management does have to turn over information, especially if it's important to your grievance. Anything that is going to be used against the person has to be shown to you. So that is true. And it's something that I think Will was talking about there, right? You have the right. It's also backed by the International Labor Relations Act. So you have the right to bargain, includes the right to the relevant information. And that's huge, right? When we talked about political activism, that's what gained us these rights here. It was unions and labor people trying to get the law to match up with what we needed. And this is one part of it. If you look on the next slide, it will talk to section 8A, subsection 5, I believe, and it makes it illegal for the company to refuse to bargain, including refusal to provide the relevant information in a reasonable period of time. It's not just they don't have to, it's illegal for them to not do it. The relevant information, anything that's pertaining to the terms and conditions of their employment or anything that's going to help you enforce the contract. Usually you can go back to 2 years. It's, that's a rightful ask of the company when you're trying to investigate a contract. You're not asking them to go back 20 years from now. You're asking them to keep records that that they have. These companies do keep records for that period of time. What information should you request? So, statement that the following information is requested pursuant to the union or the union's right under the National Labor Relations Act. That's how you're kind of going to start your ask. You're going to describe the information that you're looking for. You're going to give them a deadline. I need this information by this time. And if they don't respond to you or give you the information at that time, you're going to make another request. We do it personally in my facility through email. It's a first attempt, a second attempt, and that time and date stamps it, right? So you're going to be able to prove just by your emails whether or not they're back and forth with you given the information. Give a new deadline after you make the second attempt. If they continue to fail, then you start moving on to filing ULP charges, which is now become a lot easier to do. I believe you can do that right online. So that is going to be your process for an information request. What information do you have the right to? So right here is a list, and this list is not all inclusive. I have seen there's actually a document that is the rights of information for a union steward, and there is a lot of stuff you have the right to. So I don't have it right with me or a link to it, but there is definitely information there that you can look up and find. Accident reports, the attendance records, bargaining notes, disciplinary records is huge. If you're going to go and file a grievance for an unjust discipline, you need to know what the history of that person's discipline was. Their employer manuals, the interview notes, what they're writing, what they're interviewing the person about, time cards, videotapes. I mean, if they're going to use a videotape against the person, you need to be able to see what's on that. And then their wage and salary records. So all of that is things you can ask for, but that's not the whole list. There is plenty more to it. So for a misconduct case, ask for the names and the addresses of the witness and descriptions of what their testimony was. For an arbitration hearing, ask for the names of persons and the employer or persons the employer intends to call to the stand. That's your right to know who they're going to use, what they're going to use, what information they're going to try and argue against you. So moving on, what information can you request still? You can request data, prior disciplinary actions, promotional patterns, and overtime assignments. All that kind of stuff is important too. Again, when you're building these grievances, you have to put as much into it as possible. And every piece of information and data or whatever you can grab is going to help if it goes all the way to an arbitration. It's going to give you feet to stand on or give them feet to stand on when they go to argue this. You want to request a copy of the grievance personal file. Whatever they've had happening throughout their career there, you need to know that as well. And then the employers, we actually had this happen. So we had, what are they called? Attendance hearings. And there used to be a rule on our contract that was called lost opportunity for the company or missed opportunity. So if they didn't bring a person down within a certain amount of time for their attendance hearing from the date that they had their attendance issue, they lost the opportunity to go after it. Now, there was arguing back and forth the first time that we had to enforce it, and we actually went into the notes of the International's bargaining for this, and it showed a spot where it highlighted what the amount of time was for this. It wasn't in the actual language in the contract, but it was in the notes that were bargained. So that's a huge one. I mean, if you can access that and gain something like that out of it, we were able to use that quite a bit after we found that out. So the dates and contents of any union statements upon which the employer is relying and descriptions of any incidents which the employer says support its position. You have rights to all of this. And again, these are things you should be utilizing as you're writing grievances. I can tell you from personal experience, I've asked for all of this at some point or another, and it has helped win more than enough grievances at the starting point, not even having to get too far. But if it does keep going, then yeah, you're going to want that. So here we are going to do another poll. We're going to have a day of polls. So we're going to ask this question and you obviously answer again. So 2 workers are involved in a fist fight in the plant. Only one of the workers is disciplined. The union requests the personnel files of both of the workers. The company refuses to provide the personnel file of the worker who was not disciplined. Is the union entitled to this information? That's a lot of people in favor so far. So we'll answer it now because it seems very heavy on one side. Yes, you are entitled to this information. That is your membership. If they are treating people differently, you have a right to know that, and you have a right to utilize that in your argument against them. The next one, got another one. So a worker was discharged for leaving work early and not punching out. The union believes that the other workers guilty of this offense in the past have received a lesser penalty. The union requested disciplinary records of the other employees. The union responds, or the company responds, that the disciplinary records of those other employees are not relevant to the present discharge. The company representatives then say that if the union gets the written permission of the other employees to review the records, the company will consider the request. Does the union need written permission? I think we got some people who maybe have been union stewards in here. Okay, so you guys are right. You do not need written permission from your membership. You are their elected leadership. You have the right to represent them, which means you have the right to all that information. So no, you do not need that permission. Going on to the next poll. The union suspects the company has been in violation of the equalization of overtime language in the contract. It requests records of all overtime worked in the last 12 months. The company informed the union that this is not required to supply, or that is not required to supply the information because there is no active grievance filed over the overtime issue. The first question we're going to ask is the union entitled to this information? All right. So yes, you are entitled to the information. This is part of what we were talking about of things you're allowed to ask for. Yes, you're allowed to ask for this. The second part of this question is, can you get the information for the past 5 years? So let's see what you guys think on that. That one's a little closer. All right, so we had discussed this just a little bit ago. Usually within a 2-year span, there's not going to be an issue asking for that information. Once you get past that, that's where you're probably going to get some pushback. I would always start with 2 years, and then if you really want to test it, try and push for the 5. But 2 is where they've kind of put the limit on what they need to give you. Now, in my facility, we keep records of our overtime as well. So we have records going back to 10 plus years. So we can always activate our own files if they don't want to give it to us. But again, these are things that the company is supposed to be providing. I'm going to hand it back over to Will here.
Thanks, Ricky. So we've talked about filing a grievance. We've talked about, if we go back a slide, I just want to talk generally for a sec before we get into the poll. We've talked about grievance, we've talked about requests for information, and now we want to talk a little about some more of the specifics about what happens in meetings with management. Mostly we're talking about Weingarten meetings, but some of what we're going to talk about applies generally when it's bargaining, other things that might come up, talking through potential MOUs, that kind of thing. I do want to focus briefly, specifically on a Weingarten meeting and the extent of the Weingarten rights, because when you're in those meetings, things can move fast. You need to really have a good sense of this, so when something happens that you need to intervene on, what interventions you're allowed to make, when the Weingarten right applies. I think an important thing to note is that it applies for telephonic communication or written requests. So if a boss calls one of your workers at home and starts asking questions, that worker has a right to say, I'm not talking about this unless we can get my steward on the phone. If they demand, written answers to something, that member has a right to consult with you before writing any response. So it's important to keep in mind. When you're in a Weingarten meeting, you have the right to ask for specific charges. Like I said, you have the right to caucus, you have the right to take notes. You have the right to basically advise members on how they can respond to questions. You can object to harassing questions or loaded questions. You can point out mitigating circumstances. You can't disrupt the meeting. You can't, object so much that you basically make the interview impossible, but you are allowed to make those assertions. And when the boss is not following the law, when they're refusing to tell you what's being investigated or refusing to let you and the member caucus, you can direct the worker not to answer. So it's important to note kind of how expansive this right is and exactly when it applies. It's also important to note that these things can get a little contentious. And now we're going to jump to our poll for this section. Can a steward swear at a manager during a grievance hearing? Let's hear what you all think about that. All right, this is a close one. All right. Here, the answer is really it depends. Well, it's a little between it depends and it's true. Some level of heatedness is expected. There is a board case that said that a frank and not always complimentary exchange of views must be expected and permitted. When it comes to these kind of conversations, it's kind of built in. As we said, there's an equality principle. It's kind of built in that the two sides are gonna be honest and potentially get a little heated. Some level of invective is acceptable. It's important to note the difference between invective and threats. So, for instance, and pardon my French, everybody, if a steward in the heat of the moment calls a manager an asshole, that's allowed. But if they say, like, I'm going to kick your ass, not allowed, that becomes a threat. It's an important line to keep in mind. The kind of overarching way that the courts look at this is through a case called Atlantic Steel. The Atlantic Steel factors where they consider where the discussion happens, the subject matter of the discussion, the nature of the outburst, and whether the heated statement was kind of solicited, provoked by a manager's behavior. So, for instance, getting in a fight like this in the manager's office is going to be a little more protected. Getting in a fight like this on the shop floor, a little less protected. Obviously, if you're talking about a grievance, that's more protected. If it's something that's less focused on your role as a steward, less protected. These things are not, there aren't particularly clear-cut lines, but generally, the more you are acting in your capacity as a steward and the more your outburst is a result of your duties as a steward, and certainly as long as there are no threats, your conduct is likely to be protected. And we're going to look at a recent change to the law. So back in 2020, in a General Motors case, the Trump-appointed chairman of the board changed the standard that made it a lot easier to discipline employees for these kinds of outbursts that take place in the conduct and in the contexts of protected activities. As Ring said, This is a long overdue change to the NLRB's approach to profanity-laced tirades and other abusive conduct in the workplace. Now, obviously, this is nonsense from Ring. This was the law for 4 years. However, we can go to the next slide. Oh, overruled. No longer the law. The new NLRB, the current board, overruled this, returned the old standard, which recognizes that these kinds of things happen all the time.
Damn right.
Sorry?
It's a damn right.
Damn right. So yeah, you have a right to zealously represent your members. Sometimes zealous representation involves, showing your emotions a little bit. So, within reason, don't be afraid to show how you feel to a boss. So this next section is on the duty of fair representation. I talked about this a little bit earlier, but it's important to go into some more detail. You have an obligation to everybody that works in the shop in your bargaining unit, whether or not they're a union member, whether or not they voted for your slate in the last election, whether or not you have political differences. You owe this duty to everybody in the bargaining unit. And what that duty is not always easy. I mean, there are plenty of situations where the interests of one member are going to be pitted against the interests of another member. If the boss gives somebody, the shift they want, but goes out of seniority, you're faced with the question of, do I enforce the seniority language in the contract or not, even if it's going to disadvantage one of my members? You have the right to make that determination. You have the ability to decide when you are going to, in what manner you're going to enforce that contract. But the point is, you have to do it in a fair way. You have to do it in an even-handed way. You have to do it in a rational way. Another good example is even members who have very clearly done the wrong thing are owed some level of representation. You shouldn't make false statements on their behalf. You shouldn't go in and make ridiculous arguments, but mitigation is part of it. If there are reasons to explain why they did what they did, you've got a duty to go in and give that kind of defense. So even guilty people are entitled to due process. We have that in our courts. We have that in our unions. So that's a really important thing to remember. That doesn't mean that you can't, make these decisions about what's best for the whole shop versus what's best for a member. You certainly don't need to, like I said, you shouldn't lie. You shouldn't make things up in order to defend somebody, but everybody deserves that due process. So some of the things that, are really just important to being a steward in general, but are also important to making sure you don't violate the duty of fair representation. Process grievances in a timely manner. Like Ricky was saying, these contracts all have time limits on them. You want to keep very good track of those time limits. Talk a little about how that can look later. Just want to communicate with members about their grievance. Don't be a black box as a steward. As information is coming into you, explain, what you're doing, what you're thinking, where in the process things are. If you're requesting information, gathering information, share that with the person who filed the grievance. They obviously care enough about whatever issue this is to go through what can be a frustrating process. So you owe it to them to make sure that they're, kept in the loop on these things. And that goes part and parcel with this third bullet point. Provide members with the information or documents related to their grievance. If you're getting this info back, unless there's some extenuating circumstance or you had to sign a confidentiality agreement, which we're talk a little about that. But generally speaking, you can share that information with members of your union in the processing of their grievance. And, they know what happened to them better than you know what happened to them in all likelihood. So they might notice things based on that information that you didn't. So it's just good grievance handling to share. But the bottom line here really is that the union has to provide these members due process. Whatever the union decides to do, it has to do that consistently, and it has to do that fairly. So we have some, and I think it's also important to note, this isn't, we talk a lot about how NLRB remedies or grievance remedies are not always great. They take a long time. DFR, you can go to federal court. If a member has their duty of fair representation violated, they can bring a suit against the union and the employer and can receive money at the end of the day. If a judge finds that, for instance, if you don't pursue a grievance in an arbitrary or capricious or discriminatory manner, and that grievance would have been valid, a court can basically find the union, put the union on the hook for the economic loss to that member as a result of your failure. So say, there's someone is fired wrongfully. The union doesn't fulfill their duty of fair representation to bring them back, pursue their grievance in the best way possible. And then a judge finds 2 years later, after all this litigation, that their rights were violated. They weren't given the duty of fair representation. If the judge finds, for instance, that the grievance process would have taken 6 months to bring them back, they'll go to the company and say, well, you're responsible for the 6 months of back pay you would have been on the hook for if this had been grieved. But union, you're responsible for 18 months of back pay because it's your fault that this person didn't have their job for 18 months. So this money can really add up. It can be a real strain on the union. So the stakes are high. And I say that just to make sure everybody's kind of on the same page about what the consequences could be. So we want to avoid that. What are some tips for avoiding breaches to the duty of fair representation? One is actually investigate thoroughly. An employee doesn't have an absolute right to have their grievance arbitrated. The union has to make that decision about whether this is something worth pursuing or not, but they have to make that decision on equal terms, and they need to make that decision in a rational way. And the only way to know if a grievance is worth pursuing is by investigating the grievance in the first place. So do that investigation in the first place so that you can back up whatever decision you ultimately make. Part of that is notify the grievant in writing of the time and place of any grievance meetings, arbitration hearings, invite them to attend even if they're not testifying. The more they're kept in the loop and know what's going on, the harder it's going to be for them to later claim that they weren't being treated fairly, they didn't know what was going on, et cetera, et cetera. If we go to the next slide, if the union decides not to arbitrate the case, notify the employee in writing and explain why. Especially if some contracts allow individual people to pursue grievances even if the union doesn't take them. Keep that in mind when it comes, we'll talk about deadlines in a bit, but if you tell someone the day before a deadline that the union's not pursuing it, they're going to have a pretty reasonable DFR argument because you denied them the ability to pursue the grievance on their own. So don't, let things get down to the wire. If you're making this decision, make the decision well in advance of the deadline so that nobody can claim that, the union was negligent in pursuing this stuff. Number 4 here, ask the grievant. Like I said, the grievant knows more than you do about what happened to them. So ask them to give feedback on every part of the process as you're investigating, as you're writing the grievance, as you're preparing for a grievance meeting or an arbitration. They'll have thoughts, so make sure to bring them in. 5, notify the grievant of the results of every meeting or decision. Just give a little report back. People want to be in the loop. Sometimes even defending a DFR that's not going to go can be a real hassle. And sometimes people file these cases just because they felt they weren't listened to. So take these kind of actions just to make sure people don't feel left out. Number 6, document your efforts. If it comes down to an actual duty of fair representation lawsuit, you're going to need to be able to show that judge everything you did to show that you fulfilled your duty. So keep good notes of your meetings. Make sure that you can actually show your work. Because that's really what this is about. It's rationalizing. It's really about being able to prove by showing someone that you did your job. And important, keep separate folders for each grievance. Take photos of the grievance that you're filing. Just keep a record of everything you have, and be an orderly person. As someone who's not always an orderly person, it's a good practice to keep little separate files on everything. And 7th, and I think this is really important, is don't miss deadlines. Have a system, give yourself don't just make a calendar notice saying this is the day we have to file this grievance by. Make a little calendar notice for we have 3 days to file this grievance. We have 5 days to file this position statement. Make sure that you never get caught by surprise, because that's a really easy way to violate the DFR. So that's the end of the DFR section. This final section, as we kind of flagged earlier, I'm going to pass back to Ricky because I'm just a lawyer. Ricky's actually on the shop floor doing this stuff, and sometimes the law is not the most effective mechanism for winning. So I'll pass back to Ricky.
So yeah, the law doesn't always lean in our favor on everything. There are ways to, there's a beautiful book that I believe Mr. Sean Fain talked about, Troublemaker's Handbook. That's a good read if you want to learn how to be a good union steward. There's a lot of stuff in there that go past just what the law gives you, right? Ways to get unique with it, to be different, to be good, to be the best you can for your membership. So it's not just about the law. We talked about this earlier, training your members to read the contract. At my facility, we are doing a did you know. It kind of mirrors the more you knew that used to be on TV, and they give you a fact every day or however often it came out. But we're doing that with our contract, and we're actually taking a journey through the contract, which is teaching people the language and how it applies to them. And then on top of it, the more that they know, the stronger they are, the more likely they are to recognize a grievance when it happens or a violation when it happens, and the more likely they are to bring it to you and or get involved. And the best thing we can do as union leaders, which everyone in here is a union leader, you are taking a stance that you want to better yourself and your membership, so you are a leader. The best thing you can do is educate them and build for the people coming behind you. We have, I think, failed that in the past and are working our best now to get that corrected. So this is done by training people. When you have a grievance, show them the language. This makes your whole union stronger. This literally builds the strength of your floor. That management, when they realize that you are going to catch it, they're less likely to try it. Doesn't mean they're not going to, but they're a lot less likely to try it. We see it in our facility because it used to be they would just tell you to write the grievance. Now I walk the floor and they ask me if there's anything they can do for me, right? We've enforced it. We have showed them that we're not going to let things get by, and they are less likely to try it at this point. Also, making it a group grievance. If it's more than one person affected by this, you can make it a group grievance. That's actually what you're taught when you take a grievance handling class, is there's different kinds of grievances, and group grievances is one of them. If you look here, this is an example of how to do that. We would usually attach this to the grievance. You want the employer's name, this is CID, we have a GID, same idea, their identification number, what department they work in. For ours, usually, if it's a group grievance, they're mostly in the same department, so it just goes up at the top. And then their seniority. I don't think we put phone numbers on ours because both the company and the union have access to that if we need them. But we personally have them sign it, which I think is big. It shows that they've seen what they're grieving and that they are all on board with being on that grievance. That shows strength to the company when you do that. So what else can you do besides filing a grievance? Petitions. We can file petitions against issues on the floor. We can wear t-shirts or button campaigns. Red Shirt Wednesday is one that we tend to do throughout most of the facilities or throughout most of the UAW, and I believe most other unions have some form of that as well. Doesn't have to just be a Red Shirt Wednesday. I know we started tie-dye Tuesdays at my plant for a little while, and we were just wearing tie-dyes. There was nothing more to it than we were all just trying to show unity. There's no action behind it, nothing coming from it. Also, I remember this, and I was talking to these guys here, by Mr. Will and Nathan, about back in the day in the 40s, they used to just sing a song like at 11 o'clock. Clock would hit 11, the whole plant would start singing something. Back in those days, the songs were, usually union based or something, but management has no clue what's going on. And then, not going to lie, it scares the hell out of them. When they see people united enough to do that, it worries them. Now they've taken actions. They've made lines farther apart, made it a little harder for that kind of stuff to happen, but there are still things like that you can do. March on the boss. Now, let me clarify this. Don't go attacking your boss, but as a group, you can bring a petition up. I think this happened at Amazon recently where they went in to air their grievances with the one of their managers there. You have the right to do that, but you got to make sure you're not threatening or anything of that nature. Informational pickets, those are always good. We did practice pickets during the contract campaign at my facility. Actually, we did them right out the union hall, and we used it as a time to educate people what was to come, and also to show the community that we're ready and the company that we're ready for whatever comes ahead. But it doesn't have to just be during a strike. You can utilize these however you see fit. Work to rule. So in our contracts, and the union's kind of motto is do your job and your job alone. We're not trying to help the company by cutting another person out of the facility. We are going to do our job the way it's supposed to be done. During expired contracts, I believe, There's more language to this, but if you guys have to make an action, this is one of the ways you could do that. But I would always make sure you're talking with your leadership when it comes to any of these things. And then strike. That is our biggest tool. And as we've seen recently, it works. It has been working over the past couple months. This has been, I believe it's been a year since we've had our new leadership involved, and what a year it's been. It feels like it's been 3 because of all the stuff that's happened, but it's big, and that's one of the greatest tools we've had for years and years. If you look at the history of the UAW, they've gotten stuff done because of strikes. Not every strike is won. The history of having that leverage has really changed the ability of workers to have a voice and to have power in their workplace. So with everything we've discussed, this is all very important, whether you're a steward, writing grievances, whether you're a member on the floor and just want to know more about the process, whether you're looking to get involved in your union, be a labor activist, all of this information that we've shown you here is huge to it. So I encourage you, please get involved. Please be a part of your team, your facility, because your voice does matter in the fights ahead. Thank you, guys.
Thank you so much, Ricky. Thank you so much, Will. So we're going to get to a few questions. We'll have time for a little bit of a Q&A at the end, but I just want to get through a couple slides first. So thanks, everyone, for your participation and for being here. I do want to say it's tough to be on your own, whether you're a new shop steward. Sadly, I agree, always work with the rest of the shop committee, but people might be on their own sometimes. You might win an election. Your shop committee might not be backing you up. You might be a member on the floor trying to get some help addressing an issue. UAWD is an organization of UAW members who are there and have your back and want to help you enforce your contract, and to also make sure that our shop stewards have the education and also sometimes the accountability needed to actually have a strong union and get grievances resolved. So please get in touch with us. We will follow up after this webinar, letting you know how to do that. But any UAW member can become a member of UAWD today. It's $25 a year at uawd.org/join. Your being a member helps us put on educational trainings, resources like this. And if you like this, there's going to be a lot more great education about how to be a militant and educated union member at our first ever convention in Detroit. It's this September 27th through 29th. Registration is $100 through July 31st. That might sound like a lot, but that pretty much just covers food for the whole weekend. It's at a union hotel. We wouldn't have it at a non-union location. So it is a good deal. When you think about it, there will be time to take classes like this, also hear inspiring stories from other people at their shops, hear about what they're doing to fight the boss, and also a time to talk strategy for everyone who wants to keep reforming this union and make it stronger. So you can register for that at uawd.org/convention, and we really hope to see you there. All right, I'm going to read a few questions for Ricky and for Will. And some people have asked also, we're going to share the slides and a recording of this with everybody, and the recording will be on YouTube. So I'm going to just read a few questions. So George says, are you going to mention special immunity for union stewards? I'm not completely sure what he means. Maybe Will, I don't know if you want to cover this. That could relate to some slides that we covered earlier.
I mean, I'm not sure if there's a specific thought that this brother has. Basically, I think what he may be referring to is the equality principle that I mentioned, that stewards kind of stand, when they're representing members, when they're acting as a steward, stand equal to the boss, and so are able to, for instance, have heated interchanges with the boss that would not be permitted if they were just another member of the shop. So I don't know if that kind of addresses what you're thinking in terms of special immunity.
And George, feel free to follow up. All right, we have a question from Scott. Where and when do the results of an investigation get attached to the grievance?
So Ours, it depends on where it ends, right? If it's at first stage, you would have the results there. Usually, if it goes the first stage, it's going to go to second stage. And if they win it, they usually bring it out and they announce the information to the grievant. After that, third stage is the same. That's still within our facility. Past that, I'm not sure just because I haven't had that far into it. Maybe Will would know, but that's where we have it in the first three stages.
Yeah, I think it really varies depending on the specifics of your particular grievance and arbitration provision, but I think basically I 100% what Ricky said.
All right. And relatedly, I see a question from Jesse saying it would be great to have a class tailored to specific units. So yeah, this was a very general class about what, no matter what contract you're working under, no matter what workplace you're in, UAWD is definitely planning more classes. Specifically, I think there should be some coming up in the next few months focused on the big three and enforcing certain parts of the contract. So yeah, that's a great point, and we definitely hope to do a lot more of that in the future. And yet another reason for, anyone can come to these, but yet another reason, if you're into that kind of thing, to join UAWD. All right. Looking to see some more questions. All right, George is satisfied with that answer. I see a question from Rooster. What was the time limit allowed for missed opportunities Ricky was speaking of? I'm not totally sure.
Yeah, I can speak to that.
Okay, yeah, go ahead, Ricky.
So during ours, and this has changed since the new contracts came in. It actually changed in 2019, I think, is when we lost it, but it was the contract part of that. It was actually a 2-week period. So it was specific to the bargaining notes. It's not in everyone's contract. It's not everywhere throughout every local. But we had found out because we had people that were on the bargaining team that had happened. So they actually found it. Didn't say 14 days. It said 2 weeks. So it was a little bit gray, but we utilized it as if it wasn't done within the week of or the week after, they missed the opportunity on it. So that's where that was. Again, that's not in everyone's language. So you'd have to look that up at your specific local.
Great. I'm going to take one more question. Thank you, everyone, for being on. This is a good conversation, but I see a good question from Judy. Can a grievant get copies of the union's demands and management's responses all the way through arbitration?
So I'll say if they end up bringing a DFR case, a grievant can get that in discovery. So certainly, if you're a steward, handle yourself fully in the knowledge that if a grievant ends up filing a DFR, they can get that stuff in discovery. Absent that kind of litigation, I think it's going to vary very much on kind of practices and policies in a particular shop and in a particular local and a particular company. A very indeterminate answer. Sorry.
No. Just to speak to that, it just, I think before it gets to that stage that Will is talking about, it depends on your elected stewards, right? That's why we have the right to elect. So someone like me, I'm going to keep you updated throughout the process. This is what we asked for. This is what they said. I'm moving it to this stage. It's won at this stage. It's lost at this stage, what have you, right? But it depends on your steward. And then, yeah, if you don't feel like you're representative, then you take that course there. But that's why we have elections too, so that we can, if someone's not being fair with you, that's what that process is for. But
yeah, and I think just to add, Will is definitely focused on, well, what is the bare minimum here that your union has to do? But I would say that us at UAWD, we very much agree with Ricky's perspective that a shop steward doing a good job, the kind of steward committee person we want to see is going to provide as much information as possible. But yeah, that's a great question. All right, I don't see many more questions coming in, so I'm just going to end by saying thank you for being here on a Sunday, taking time out of your day to get more involved, more educated in the UAW and your union. And we really hope that you'll join in for future trainings like this, and you'll take this knowledge and help enforce your contracts, whether as a rank and file member or as an elected member of the shop committee or as a shop steward. So thank you, everyone, for being here, and we will definitely be in touch with these slides and with the recording. But yeah, thank you so much. And thanks again to Will and Ricky for being such great panelists and educators. Appreciate both of you.